healthcare surrogate is really good.
I worked in a nursing home.
Ah. Did you ever see a healthcare surrogate?
Often.
Really? I'm very interested. We don't see many of them anymore. All right, so we want to be thinking about a power of attorney, financial and medical. We want to be thinking about an advanced healthcare directive. We want to make sure, and we also want to do a will. When we go through this planning process, we might as well go ahead and do a will. And you might be surprised to hear an elder law attorney say, as the last thing of a long list of tasks, do a will. I really find a will to be maybe the least important of all these documents. You know what? Property's property. When you're gone, you're gone. It's going to get worked out. Somebody's going to get it. Somebody's not going to get it. But during your lifetime, how much more important is it that you have someone you trust making decisions for you? How much more important is it that in the last 3, 5, 6, 7, however long years of your life, that you're being taken care of, decisions are being made about your life by someone that you love and trust to make good decisions for you? No comparison. No comparison. So, when we go through this planning process, one of the first things that we want to do is make sure that our clients have all of these things taken care of. So, what does it matter? Why do we do this early? Why don't we just wait until they need one? Why don't we just wait until they get to the point where they really need someone to help them make financial decisions, or they need someone to make healthcare decisions for them? Why not just wait then?
Because by that time they've lost the capacity to consent for services.
Exactly. I mean, we don't want to wait until the point where they're incapacitated. Once they're incapacitated, what is our option? If we reach the point where they're incapacitated, at that point, they no longer have legal capacity to execute a durable power of attorney to appoint someone that they would choose. They no longer have the capacity to execute a healthcare power of attorney to appoint someone to make healthcare decisions, someone that they would choose. They no longer have the capacity to make a will. If they can't do those things, what are their options at that point?
Kids fighting.
Well, the kids are going to fight. That's a given.
Being incapable or incompetent.
And what's going to happen when they're deemed to be incapable or incapacitated?
All their rights, yeah.
Okay, but what's going to happen? Who's going to make decisions for them then?
Guardian.
A guardian or conservator. Once we reach this point, we have to have a guardian and or conservator. Now that guardian or conservator might be someone you know. It might be someone you've never met before in your life. You have no control over that appointment process. Now there is a priority of appointment. And the priority of appointment is spouse, child, parent. That's the first 3 steps. After that, you get a little bit further afield. Now, one of the nice things about executing a durable power of attorney is not only do you get to appoint the person that you trust and want to handle your financial and healthcare decision making, but also that by virtue of that appointment, if your document is drafted that way, the person that you choose in that document goes automatically to the top of the list. And so if there comes a point where a court decides, hey, your durable power of attorney is not sufficient for this individual to make decisions for you, you have to have a guardian and conservator. If your durable power of attorney is carefully drafted, this person that you've already appointed and that you trust moves to the top of the list and is presumptively the person to be appointed. So now you've guaranteed that no matter whether they're acting because you have voluntarily appointed them, or if they're acting because they are a guardian, if your durable power of attorney is carefully drafted, you can guarantee that the same person is going to be making the decisions. You don't have to be worried about the result of that appointment process. So let's talk a little bit about durable powers of attorney. Durable powers of attorney are not cookie-cutter documents. They're not all the same. They don't say the same thing. They're not the same length. They don't have the same terms. Every one of them is different. And so whenever I have a student come to me and say, oh yes, well, they're their agent under a durable power of attorney, I say, okay, to do what? I'm like, well, under Alabama law, an agent can do anything that a principal can do, except they can't write a will for them. And if they have a will, they can't change it. But other than that, an agent can do anything that a principal could do. I say, okay, so you're telling me that this agent has authority to do anything that this principal could do. And sometimes they say, well, you're right. My smarter students say, well, I guess I need to go back and look. That's exactly right. What they can do is governed by the document. So when we're looking at a durable power of attorney, the first thing we have to do is read the doggone document. How many of you have bought a car? Raise your hand if you've ever bought a car. All right. When you bought that car, you signed a durable power of attorney. You may not have been aware of it at the time, but you did. And if you were to go back through all the documents that you got the dealer, you know, the ones you didn't sign because you were so excited about getting the car, you just signed everything they handed to you and handed them back? Those documents? I know, I do it all the time. My wife gets on me. Anyway, if you were to go back through those documents, you would find, nestled in the middle of it, a durable power of attorney. And it says, I appoint Townsend Honda as my legal agent under Alabama law under this limited durable power of attorney for the sole purpose of applying for title for my vehicle. And so you appointed an agent under a durable power of attorney for only one purpose, to apply for title to your car. That's the only authority that they had. And it lapsed when that title was applied for. So that's an example of a very limited power of attorney. So you can imagine that if you're in my line of work, and what you're trying to do is prepare for your client eventually losing their capacity or competency to make their own decisions, this is not what I want. That's not what I want. This is what I want. I want a very general durable power of attorney because I want that agent to be able to do anything I could do. Because the last thing you want to discover is that your appointed legal agent doesn't have authority to do the one thing they needed to do. Because now they have to go and get a guardianship, which is what you were trying to avoid when you signed the doggone document. So you want to make sure when you execute a durable power of attorney that it grants the authority you want your agent to have. And if you're planning for incapacity, then you want it to be general. The next thing that we want to look for is we want to look to make sure that the instrument itself is durable. Can anybody tell me what a durable instrument is? What makes it durable?
Hold up the scrutiny.
Well, we hope it does that, but that's not why it's durable. That's a good guess. By else. A power of attorney is durable if it survives your incapacity. And so when you're looking at a power of attorney, you want to find language in there that says, this appointment shall not be affected by my subsequent incapacity, incompetency, or disability. If it's not durable, it is not effective as a planning tool. If you're planning for eventual incapacity, then if your incapacity invalidates the appointment, then you really haven't planned for incapacity. So you have to make sure it's durable. You look for those words of durability, okay, in the instrument itself. So we want to read the document. We want to see if it's limited or general. We want to draft it as a general document if we're planning. We want to make sure that it's durable, okay? And then we have to make sure that we decide whether it is going to be express or springing. Okay. Now, an express durable power of attorney takes effect immediately. It says this document shall be effective immediately and shall continue in effect unless and until I subsequently revoke it. Whereas a springing power of attorney only becomes effective upon some event. This durable power of attorney shall become effective when. Okay. Now, as a drafting issue for my law students, one of the things that I emphasize with them is that they must clearly define the event. What is it that causes this to come into effect? So it needs to be language that is extremely clear, like this durable power of attorney shall take effect upon my 80th birthday. This durable power of attorney shall take effect upon my disability or incapacity or incompetency as determined by a letter from my treating physician. This durable power of attorney shall take effect and become effective only upon my disability, incapacity, or incompetency as determined by 2 primary care physicians or some other equally clear event. In the absence of that clear event that causes this authority to spring into effect, it may never spring into effect. And or your family may argue about whether it has in fact become effective. And if you reach the point where your family is arguing about whether it is effective or not effective, you might as well be in a guardianship and conservatorship case. Because you're in court, you're having to argue about who ought to get to make decisions for mom or dad anyway. So you've defeated the purpose of this planning process. I always tell my students, whenever you end up in court over who gets to make decisions, you have failed as a planning lawyer. And if your job is to plan for that eventual incapacity, and that event occurs, and there's not a clear decision maker appointed, you've failed. Doesn't matter that you had the best of intentions, you failed. You've got to get that event has to have clear consequences, and those clear consequences have to be, my daughter's in charge of my financial affairs, my son's in charge of my medical decision making, I've got my advanced health care directive already drafted and done and signed and executed, and it's in effect, and I have a health care proxy appointed under it, and my will's done. Those things have to be done when we reach that point of incapacity. So, this is a durable power of attorney. It may be financial or it may be for health care purposes. Now, about 10 years ago, attorneys decided that a power of attorney instrument should not address both financial and medical decision making. Why do you suppose that elder law attorneys really led the way to say, you know what, these ought to be separate documents? Why do you think they decided that we can't just have one? Any ideas? Why did we have to separate it out?
Make sure they're more specific.
Well, you know what? I can be really specific and have them all in there. It's just going to end up being 50 pages long. But I've seen those.
Conflict of interest.
Conflict of interest, how?
You got the person that's making your medical decisions is also in charge of making your financial decisions. Your medical incapacity may be temporary, but they've invoked it, and now not only are they making your medical decisions for you, they're now making your financial decisions for you. That sets you up for exploitation. If for whatever reason you come out of the medically induced incapacitation, you don't have anything left because your financial power of attorney has just dropped the line.
Correct. That is a risk. But it's a risk that's subject to a breach of fiduciary duty claim, which could get you stuck with a whole bunch of damages and possible jail time. So, yes, there is a potential conflict. There are other reasons. There are policy reasons why. Anybody? Well, I'll tell you. One of the reasons is my wife is a doctor. She's not great with money, but doggone it, she knows all about medical affairs. So it may be that my wife is a great person to be my agent under a healthcare power of attorney. But my brother's a CPA. He's great with money. I would never let him make a healthcare decision for me. Never. But he'd be great with my money. He's dynamite with my money. And so you have to recognize that one size doesn't fit all here. You may not have one person who is your very best decision maker for medical and for financial affairs. So lots and lots of people want to appoint someone different to make medical decisions versus the person that they would hire to make legal decisions. So let's see. We have different, I'll just say, may want to appoint different agents. And the third reason why is that it was HIPAA driven. It was HIPAA driven because what happened when HIPAA came out, when we had all this health information protection invoked by federal law and penalties resulting from unauthorized disclosure of medical records, is that everybody got paranoid. Everybody got paranoid. It didn't matter what your durable power of attorney instrument said. If it wasn't their HIPAA disclosure form, they weren't going to give you any medical records. That still persists somewhat today, but it's better than it was 5-10 years ago. So what we discovered was if I handed someone a general durable power of attorney and said, here, this authorizes me to look at medical records, most doctors' offices would send them back to us and say, we can't tell whether this addresses medical decision-making, access to medical records, and we're not going to pay an attorney to interpret this 50-page durable power of attorney document that you gave us. We're just not going to go there. We're not going to do it. So if you don't have a patient who has the capacity and competency to sign over our HIPAA release, then you're just not going to be able to look at those records.